As an estate planning attorney, my entire job surrounds around two major questions. Both of these questions, in my opinion, are two of the most important questions that everyone will deal with in one way or another in their life. The first question is this: if you did not wake up tomorrow, what would happen to your assets and your children? Seriously, if you were not here tomorrow, what would happen to the stuff that you own? No matter how much or how little, what would happen? And I want you to think about that for a second. I know we don't like to talk about that, but we got to plan around that. The second question is equally important. If you woke up tomorrow and you were suddenly incapacitated, who would make decisions for you? And what decisions would they make? Statistics show that about 60% of people cannot answer these questions correctly. There are all kinds of reasons that I hear. They're concerned that they might be jinxing themselves, or they figure they have more time, or they just haven't gotten around to it because they're so busy. All of that makes sense to me. However, if you pass without the proper kind of plan in place, most likely your assets are going to have to go through probate court before they can get to anybody that you want them to go to. Even in situations where people aren't fighting, there's still three components of probate court that people want to avoid: time, cost, and publicity. When we talk about time, probate court by rule is going to take about 4 to 6 months before it can close. If people fight, that causes it to drag on beyond that. A regular case is going to last about a year. Probate court has filing fees, which range around $300 to get the case started. In addition to that, attorneys are going to charge you anywhere between $2,000 and $6,000 to take you through a regular case. When we have fighting and controversy, that easily takes it into 5 figures, maybe 6 figures or more. But then there's what's called an inventory fee based on the value of the assets that are coming through the probate court process. Keep in mind, all these costs come out of your assets before anybody gets anything. The third factor, though, is the one that typically disturbs people the most, even though it's the simplest. That's publicity. A lot of celebrities are teaching us about this right now. When you pass without the right kind of plan in place and a probate case is opened in your name, it's open to the public. Anybody can go to the court. They can pull your file. They can find out about what you own. They can find out all about your debt. A lot of people don't like the idea of that. And television has taught us that the way you avoid probate court is by having a will done. We see on TV the reading of the last will and testament. What they don't show you on television is that that happens after probate court, because a will is nothing more than a letter to the court saying who should be in charge of the probate court case, number one, and who gets everything after the time, cost, and publicity of probate court, number two. It has no value without an open probate court proceeding. So what's the best way to avoid probate court? It's a trust. Now let me start by saying not everyone needs a trust, but in many cases, a trust is the chosen method. Here's why. At its fundamental level, a trust helps you avoid probate court. But it only works if two things happen. You have to have your trust built correctly. Now, if you think of the trust as like a big bucket, the first step is to hire an expert bucket builder to build that bucket. The second step is to make sure you properly connect all of your assets to that bucket. If that happens, then things should stay out of the probate court process and travel exactly like you wanted them to travel. At TGQ Law, we are experts in estate planning. I require all attorneys who come into my firm to be trained in this area. And most importantly, I'm passionate about this. I want to make sure that your plan is exactly like you want it and complies with the laws of the state of Michigan. Now, all of that deals with the first question: what happens after you're gone? Let's now deal with the second question: what happens if you're alive but need somebody to handle business for you? These are your powers of attorney. Everyone, in my opinion, 18 and up, should have a financial power of attorney as well as a healthcare power of attorney. With these documents, what you're doing is appointing somebody to handle business for you while you're alive. If you don't have these things in place, your family's going to be stuck begging a court to appoint them. I'm sure that's not what you want. So the proper thing is to contact an expert estate planning attorney to make sure that you properly build, maintain, protect, and leave your assets in the way that you want. Now is the time to make sure you take care of that and put the right kind of plan in place. Once that's done, get on with life.